All right. How did everybody like that jingle, huh? A little Irish dance in
Oh my
there.
God. I still can't believe you did that.
All right, everyone. Welcome to the LoJo Show. I am your host, LoViture Jones. I am the founder and managing partner at BlackRock Engineering and Technology. I have over 21 years of cybersecurity experience, and I am honored to be able to bring some of that experience to you. Welcome to Season 2. We are using a new, more engaging format to help our listeners digest our episodes easily. Today, we are going to dive into some cyber news, give you our analysis, and talk about the legal consequences of poor cybersecurity. I am also joined here by Jonathan the Ludite, is what you guys know him from as far as the first season here. But today, he is just Jonathan Logan, our producer. I'm really happy to have him on. He's a very smart, talented individual. He's not very good looking.
That's true. I have a face for radio, though.
He does have a face for radio.
That's why I'm doing this podcast.
Perfect. Yeah. Listen to that silky smooth podcast voice as he was bragging earlier today. So today we're going to have the battles of Silky Smooth.
The battle of Silky Smooth.
Silky Smooth.
Oh, God.
You know why we're talking Silky Smooth? Because we're going to get into some legal discussions today.
Are you saying that like lawyers speak Silky
It is.
Smooth?
It's lawyers speak. However, we need to at least go ahead and let everybody know that we are not attorneys. We can only read case files.
Isn't that what attorneys do?
I think that's what they do. It's kind of funny, right? I think they literally go to school for 4 more years of law to write essays and memorize law that actually they will usually have in a book or, online now.
Yeah.
To be able to reference court cases.
My mom always said I should be a lawyer because I'm great at arguing.
So I don't know if that's true. I mean, if you look at like most lawyers, or a lot of them are divorced. So apparently they can't argue very well because they can't even convince their spouse to stay.
Or they argue too well and their spouse just doesn't want to deal with it.
That might be the case, but I still think that they're horrible arguers. I mean, at the end, they might do well at the, when there's like structure to the argument in the case, but the wife can bring up circumstantial evidence all the time. There's nothing you can do. And now we're just assuming that every lawyer is a man in this case. God. So,
all right, so this
we
is
digress.
Jeez.
We digress. All right, John, we got topic number 1, cyber news.
Yes, that's correct.
All right, so this is the moment where John sits me down like I am a little kindergarten student and reads to me articles. So let's go. Let's start. What do we got?
I read the article so the listener can know what you're digesting and what you're, giving your analysis of.
Oh, so this is more advanced than
yes.
That. So there's a difference on this one.
Yes. No, this is just, I'm reading it so they can hear what we're going to be discussing.
But aren't you going to ask me how do I feel?
No, I don't care how you feel.
About the article?
No, it's just I want your analysis. I want your brain, not your heart.
That is a really, I mean, you got issues.
All right. So the first one we have today is from Sarah Coble at infosecuritymagazine.com. The title is Lawsuit Filed Over Contact Tracing Data Breach. A federal lawsuit has been filed against Pennsylvania and a vendor contracted by the state's Department of Health over a data breach that exposed the personal health information of thousands of Pennsylvanians. The DOH hired Atlanta-based company Insight Global in 2020 to provide contact tracing and other similar services following the outbreak of COVID-19. The department later said that employees of the company caused a data breach by creating unauthorized documents outside of the secure data systems created by the Commonwealth. Information exposed in the data breach included names, phone numbers, and medical information belonging to 72,000 individuals. The data breach was first reported by WPXI TV show Target 11 on April 30th after the show's team learned of the incident via a whistleblower. The show's investigator, Rick Earl, today reported that a lawsuit has been filed over the breach. Insight Global and the Pennsylvania Department of Health are named as defendants in the suit, which claims that the data breach victims now face an increased risk of identity theft. The plaintiffs allege that the data breach was a direct result of the defendant's failure to implement adequate and reasonable cybersecurity procedures and protocols. In the suit, Insight Global is accused of maintaining unsecure spreadsheets databases, and or documents containing the public health information. In a statement by the company sent to Earl, Insight Global claimed to be unaware of any litigation regarding the data breach. Insight Global has not been served with the lawsuit and will need time to analyze any allegations, but can say that they're working closely with the Pennsylvania Department of Health to identify any individuals whose information may have been affected. Your thoughts, your feelings.
You remember that little like jingle you did as a kid, and it had this little line in it that was like,
Oscar Mayer?
step on a crack and you break your mama's back, right?
Is that I think that's a limerick. I don't think that's a...
I don't know what it's from. I just know that it was something that we said. Usually, if we were jump roping, it was something like that. And then, or if you're
that's
walking
hopscotch,
down the street, or
yeah.
no, jump roping is not hopscotch.
No, but you said step on a crack, break your mama's back.
That
that's
wasn't hopscotch.
Yeah.
Oh, okay. All right. It was a hopscotch.
Step on a line, break your father's spine.
So, yeah. So let's just dive into this, right? There's this term out there called speculative future harm, right? Hard as hell to prove. It is so difficult to prove it that most of the cases out there that have tried to use this have died and just absolutely just flopped on the edge of the river when you pull a fish out and just died, ran out of air, right? Ran out of oxygen, okay? And here's the thing. For you to actually be able to move forward with these lawsuits, which is becoming more and fewer far between, right? You got to prove that there was an injury, right? That you were actually hurt, legitimately hurt, right? And then you've got to then prove that the injury was caused by whatever company or organization's conduct. And then, by some miracle, you've also got to prove that the injury can likely be redressed by a favorable judicial decision, which has not occurred, right?
Like ever, or...
It occurs where you see some companies will settle, but really usually when they settle, it's more so to, one, maybe reduce some of the damages, but more so because, one, their brand is also taking a very bad hit at that point in time, so they need to move and look like they're doing something.
So for optics, they just settled to get it out of the news and stuff?
Yeah, to get it out of the news and to really, to really do that. So it is very, very difficult, right now in the year of 2022 to really prove that, hey, speculatively, I could be harmed in the future because my data was stolen, and so therefore I am worried, and I have to think about the fact that that data could be used for something,
Right.
Later on down the road. So the only problem is, again, it's not material. It's not material enough for a company or for a plaintiff in that case to be able to say that, hey, I've got damages, right, and it's their fault, specifically their fault, right? And we see that in a number of different cases out there. There's some definitely resources and stuff too that we'll cite, that's on the site. I don't want to go into each one of these cases and stuff that's out there right now, but it's very difficult to prove that you have actually been injured and that it's actually directly that company's fault for those injuries. Here's where companies and stuff have to really kind of show, or what they have to demonstrate, just to say, hey, you know what? We did all we could. This, in some cases we did 90% of what we should have done, but it just didn't happen. So one of the things is that a company just really has to prove that they, put in at least proper due diligence and stuff for prevention, to prevent a breach or prevent a security incident from happening that, that expose people's data, right? Showing that they have a program in place and those types of things, which honestly, from a measure standpoint, isn't hard for them in some cases, right? The other complication too, that's here, is that we are so interconnected when it comes to data, and how that data is both aggregated, parsed, and or disseminated. There are many, many parties that are involved in that. So in a lot of cases, it's very hard to prove that only the party that you're actually trying to either sue or bring a lawsuit against is the one that's solely responsible for the damages that that organization has, damages that an individual has has realized. Okay. The other part to this is that when we think about kind of, again, that term speculative future harm, it kind of goes to the same thing of, of stock, right? Past performance does not indicate future, success or future performance and stuff that's there, right? It really does not. I mean, our data and stuff has been compromised and breached in some cases because of our own actions and activities too. So you can't even in some cases you can't even distinguish that, hey, this was part of that breach there. My information got out on that breach specifically, and that is a person that's responsible for it. Well, if you had a Google account, or if you had a Hotmail account, or if you had a Yahoo account, or whichever over the years, and it's been breached, and say you had emails in that account that had your personal information in it, how do you know it wasn't that information in that time that actually, started that harm, right? That's really the hardest part to prove, right? Is that
Who's at
you were
fault
damaged by that? Who was at fault?
Yeah.
Were they specifically at fault? And so what that does is that kind of ends up reducing what your damages look like. So you can't just go in and say, hey, they stole my information. I want $1 million.
Yeah.
Right? The most you're probably going to get is, hey, we're going to give you a free subscription to this, data protection site or whichever, right? Or, or credit monitoring site. And, they have a free subscription to McAfee for your computer, right?
McAfee.
Right. So you end up with those because it's very hard to prove damages. It's very hard to prove that they got your specific information in that breach because of the negligence of that company, right?
Well, in this article, it's saying the Department of Health said that the breach happened because unauthorized documents outside of the secure data systems were created by the Commonwealth. And so the plaintiffs are saying that the data breach was a direct result of the defendant's failure to implement adequate and reasonable cybersecurity procedures and protocols. So it doesn't seem like they're trying to say like it wasn't like they're the one that lost the data, but because they didn't have the right protocols, they're going to sue them because it could be them.
Yeah. So that is the next approach, right? Okay. So how that's described is that next evolution, right? It used to be the company said, look, we did what we could. We used, we used the security. We protected it in the best way that we knew we could, right? So that additional information on that article, right, where you say, hey, they knew how they were supposed to be doing this. They had a policy for it, right?
And they didn't follow it.
And they didn't follow it, right? But again, even though they may have those faults and they didn't follow those policies or so in the daily conduct of business and administration, how are you going to prove that you were damaged by that?
So you're saying that they can prove that they didn't follow procedures, but they can't prove damages, so they won't win?
Yeah, you got to prove that an injury in fact happened and occurred, right? And then you also have to know that injury was caused by the defendant's conduct. Right? So, I mean, it's kind of like this. I have my phone. I have my iPhone. I have your contact information in my iPhone, right? I've got your email address, and who knows? I probably have documents on my iPhone because of the connected folders and all that stuff that that we have and things too through that. Now, granted, it's protected, but again, somebody gets in possession of that, or somebody is say it's left on, somebody gets in possession of that. In that case, well, yeah, there might be some things and information they can get off of it that's useful, and that might be your information, right? But again, it comes down to how were you damaged on that day? How were you actually damaged or injured? Right? Was there something material that you were injured by, right? So like car crash, that's pretty easy, right? Car crash is okay, actions. He drank too much that night, got in the car, drove, plowed into me, broke my arm, broke my leg, broke my hip.
Yeah, that's very clear cut and
now
dry.
It's pretty
who's
clear,
at fault.
right? That hey, I have injury. Your actions directly contributed to that injury, and likely it's going to be found that you had fault with that, and that you should be held accountable for that in compensation or whichever from there, right? And then it turns to the insurance company that's there, and the insurance company fights it, and then the insurance company's like, let's settle, and there you go, and then they cut you off, they cut the driver off from their insurance after that, right? They're like, we don't want you anymore, we're moving on, right? So that's the, there's the simplified road that we normally have as far as just in regular personal injury and stuff too from that, but moving over into cyber, well, everything is more virtual, right? It's more of a timing thing, right? Were you actually injured because your name and information went out there? I'll be honest with you. If you know those little sweepstakes they used to do for cruises where you go to the store and you write on the little ticket there and you stick the ticket into the little box, right? And then they have a drawing to see who wins the cruise.
No, I don't.
You've never seen that?
I might have. I just don't pay attention to that kind of stuff. I don't gamble or anything. Don't play lottery.
This is why we call him Jonathan the Luddite. Right there. That answer right there. Anyway, for those of you who have a life
Wow.
and are normal,
Wow.
you do remember going to 7-Eleven, McDonald's, other places, and writing your name in a raffle and putting that information on a ticket with your name, address, phone number.
Was this like in
date
the
of
60s
birth.
when you were a kid?
I wasn't even around in the 60s, right? And then, somewhere magically at some point they're going to do a drawing and you had the possibility of winning these sweepstakes, right? Well, you put down a lot of information there, right? That's a whole lot of information that you put there. So somebody has it now. They have that information, right? So these are things where, again, you can't distinguish where the damage occurred or who was really at fault of it, right? There's always a very good argument against, hey, no, we weren't solely responsible for this. You have actions too that could have exposed your information and data. So it's just very hard to really prove that.
So the article kind of brings up an interesting point about the regulatory and compliance. And this lawsuit is trying to sue them because they weren't following their compliance, like their own procedures, because they wrote the procedures to be compliant. So do you think, how do I word this? Do you think that there's a future for these kind of lawsuits for the plaintiffs to win if they stick more to the, hey, you didn't follow the government's regulation, and so now we're suing you?
Yeah, so this is how weird and twisted our world is, right? The organization of this your information, like if they are associated with, let's say, particular standards or body or someone in which they have agreements with, that they will provide this level of security and capability there. So company corp-to-corp lawsuits in these regards have been much more successful than individual class action lawsuits to these organizations. So corp to corp, where companies have agreements between each other that they will secure their information at this level, or there are some lots of what some of the punitive damages could be for that, and that's already known between the parties when they sign on the dotted line, right? Those have been much more successful in actually getting to settlements, as well as in some cases being successfully litigated and stuff too. So you find that those have been much more successful there, right?
On a corporate to corporate level.
Yeah, on corporate to corporate level, as far as this company is going to sue that company because they trusted them with this information. And so that is now they can actually say, hey, we were materially damaged by this because now our clients' information and customer information is out there. And now our customers are going to look to us at this point in time and say, so now you definitely have a customer, right, that's there. Now, there are probably conditions that have been put in place, like saying, hey, like for instance, let's take an Equifax, right? Where they had third-party agreements and stuff that were all in place because Equifax is through all sorts of stuff, right? From both your, we know them as credit monitoring, right? They're actually they actually have a very, very extensive, capability as far as in big data, right? Being able to do analytics and stuff too, as far as information about demographics and spending and spending habits and all those types of things. They have tons and tons of information, right? That's there, and that's with any of the credit bureaus, right? That's out there. They have all this information and data about that, but they get that, and they also help in providing that to third parties and everything else for them to do whatever they need to do with their business, right? So it's a very lucrative business that they have, and a lucrative business model that's out there for the TransUnions, the Equifaxes, and the what's the third guy? Experian, right? So these are they're just a kind of an example of how complex that road can go. But with that, there are agreements and stuff that are made. You got third-party agreements, memorandums of understanding, and everything else that determines, hey, we expect that you're going to do this, and that we are going to provide this level of security. You're going to provide this level of security, and that's how we're going to make sure that our clients are protected. So if one of them violates that, you've already set the structure there for there to be consequences and stuff that can be done there.
Would that kind of thing be written into like an NDA, or just how would that be?
Those agreements
that
I was just saying.
established. Yeah,
like I was saying, those agreements there.
Yeah.
So typically the companies will come into those agreements. In some cases, it'd be in like NDAs or even PIAs and stuff too that those organizations have in order to protect themselves as well as their customers as party to those those agreements. So that's why it's a bit easier for them to actually go in that direction. And then you have kind of you really do have the other piece, and we'll talk about this kind of in topic 2, and that's the cyber insurance component to this.
Well, that actually transitions into our next section perfectly. So
yeah, I was trying to steal your thunder.
It's okay. I mean, it's your show. Your name's on the title, so I'm just here to hold your hand.
But you're the producer.
I know, but it's your show. I just hold your hand.
Don't hold my hand.
I won't tell anybody.
That's just creepy.
All right, so the topic of this episode is going to be like cybersecurity, like the legality, how all that system works, litigation. We already kind of touched on that. Cyber insurance, how all that works. Mm-hmm. So the floor is open for you.
All right. Cyber insurance. So if you look at some of the legal publications and stuff out there, as well as even on, carrying cyber insurance, one of the things you're going to find is that, and I've probably said this on the show a couple of times, is that there are a number of different ways that companies are being surprised and having their own claims denied in the event of data breaches or cyber events or so that should be covered by these, by these policies, or that they think should be covered by these policies. But let's talk about some of the structure here for cyber insurance, right? One is you need to pay attention to the policy exclusions. Okay, big companies, I think you guys are have this under control at this point, but it's our medium companies and smaller companies that are saying, okay, you know what, I need to get cyber insurance. And the first thing you look for when you're doing insurance a lot of times is, how can I pay the least to get a lot, right?
Yeah.
Or I just need it, so I'll just get it so I can check that box. In this current day and age, you need to probably dig just a bit deeper, okay? So let's talk about cyber insurance. So really, there are really kind of 6 things that you want to really keep an eye on. One are the policy exclusions, right? Policy exclusions in this case are kind of one of the biggest reasons why claims are denied when companies have cyber insurance, right? And for that, basically, the company is stating in your policy what does not apply, right? Or how something can be actually voided, or what circumstance they will not cover, right? And so those things are already written in there. So you need to pay very, very close attention to those. And it needs to be adequately applied or adequately adjusted to. You need to adjust adequately to your industry, right? Different industries are susceptible to different types of attacks and also different types of circumstances in which there's a breach that occurs. So when you look at those exclusions, make sure that they are applicable, because you do not want to have a cyber insurance coverage that's probably more applicable to the construction industry, but you're trying to apply it to your e-commerce business.
Right, that makes sense.
Right? I mean, that's not an apples and apples thing, right? That's an apples and oranges thing, and basically you'll find yourself having paid for apples, but you got oranges, and that sucks, right? There then is, as you're going in to get a policy, there are things that you call like poor prevention practices, right? So the insurance company, when you go and you file your claim and stuff for this, right, Well, they're going to want before they give you insurance, they had you fill out this long bit of paperwork, and maybe even had a auditor or an assessor come in to assess your risk and stuff, and they made recommendations on how you can prevent certain situations so that the insurance company itself can make money, and they want to make money off your premium. But
Right.
so they've set the condition that, hey, you're going to continue to maintain these controls and capabilities, right, to prevent breaches and to prevent possible hacking and stuff in this case. So if you deviate away from that, well, then they can determine that your poor practices in that case actually was the result or resulted in that breach or that security incident.
And then you forfeit the insurance.
Yep. Yep.
Makes sense.
Another part is, these insurance companies want to see tangible evidence, really, right, in your documentation that really specifically says what your preventative measures are, right? Lining out how you protect yourself, how do you account for the different cyber threats that are associated with your industry, your operations, and most of all, on how you handle important, costly data within your organization, right? Then there's the other part of determining if a third-party stakeholder is at fault, right? Your security and both the technologies that you use within your organization and stuff from there, you've got third parties, or you're using third-party networks, right? Mm-hmm. And so your use of third-party networks in that case would be, look, hey, you said that you put in all these preventative practices and measures. Well, I see that you're using this third party over here for all of your storage, and you're using this third party over here for some parts of your critical, network operations. Well, they weren't included in our assessment of this, right? Did you assess that they were on the same page as you were?
Yeah.
Or did you just go, hey, you know what, I'm just going to do this third party thing and do this third party thing here, right? Some people in the industry would say, oh, you know what we're doing? We are offloading our risk, and we're offloading our risk to that third party. Well, be careful on how you do that, because you may also offload what your responsibility was to the insurance company, and they may say, no, you're using that third party. We didn't see where you did any due diligence whatsoever to to make sure they were in line with you. And now fault is, with you via your third party, because you failed to actually maintain and manage that third party.
Makes sense.
Right. Then there's the accidental errors and omissions. Okay. And that is where you may have not, or you have omitted some of the documentation that you should have shared with the insurer, like, for instance, that you've had breaches before, right? And that you maybe didn't quite resolve those, or that you didn't really have a post-mortem or so on that, where you've identified what was exploited, identified the reasons why, and identified what you need to do to fix it and close those particular gaps.
Right.
Right there. Maybe you didn't disclose that because you thought that would interfere with, you actually being able to get insured. Don't ever do that. Don't ever do that with regular insurance. Don't ever do that. It's better to not even have the insurance in that case than to actually...
and don't lie to the insurance company.
Yeah. Yeah. Be completely upfront and honest on it. It's much better in that case, because it really stinks to have to go through those types of discussions, as well as what are some of the legal implications for lying on an insurance policy when you've been asked specifically, what have you done? What did you do? What has prevented that? Have you ever had any type of incident here? You also swear that all the things that you've said here are true, and da-da-da, right?
Yeah, under threat of perjury.
Yeah, these things are in place for a reason, and you can't take them lightly. So to my chief risk officers and board members and stuff of organizations and companies out there, and in particular my CISOs and directors of security and stuff too, people who are being depended upon by the leadership of orgs to really make good decisions in this area, beware and be careful, but be very thorough as far as on how you answer and address your cybersecurity insurance, because the sticking points and potholes are vast and unavoidable if you are not fully transparent in what it is that you've done. Okay. And then sixth, when coverage doesn't extend beyond the interruption time frame, right? So cyber liability insurance policies vary, okay? Each company has different parts and pieces that you can construct the cybersecurity policy and stuff together with. So you need to pay close attention to what those coverage timeframes are, right? This could be a difference between having all your losses covered versus just a small percentage, of them covered. And just to let you know, a lot of this information is coming from Techie Geek. This is not stuff that's just sitting in my head. Some of it is, some of it is not. But a good resource for you guys to be able to turn to as well is to go to techiegeek.com as well to kind of look this up. They've really kind of simplified some of this topic and subject area here. Very good for just regular reading in that case. You don't see a bunch of case numbers and stuff in there. It's just very straightforward.
Not legalese.
Not legalese. No.
So,
not legalese and punctuations that you're just not used to seeing in anything that you write.
So I got a question. There's been an argument I've heard recently about how cyber insurance is actually encouraging ransomware attackers to go after companies more so than they would because they know that the company can just call their insurance and they'll get a big payout, right? So that's why you're seeing an increase in the amount of ransomware or the amount that the ransom is. So, it used to be like 50 grand, 100 grand, but now it's like $3 million, $5 million. Do you think that having cyber insurance has been encouraging these larger ransoms from cyber criminals?
I don't think that that's been the sole cause of that. I don't think that's causation. I think there's some correlation there. But again, I would say probably some of the smartest people I've ever met in my life have been in the insurance industry. And the insurance industry is very good at making money. And so anything that is really obstructing their ability or capability to make money, I have to imagine they will get rid of it, right? Or they would not allow that to keep going on in that, meaning that where we talked about things like exclusions and stuff, they will work on those exclusions to make sure that they are in the best position possible to retain the premiums that have been paid into the organization that is maintaining their insurance account and stuff too for that.
Okay. Do you think would be an alternate causation?
Well, alternate causation is that organizations don't want to be embarrassed, right? They want to conduct business as usual. And if they can get back to it as fast as possible with as little embarrassment as possible, they'll pay a ransom. And if they're a large organization, just like Colonial Pipeline, they went ahead and was like, oh, we'll go ahead and pay it, right?
Right.
Because they want to get back to business as usual.
Okay.
Right? Damn the consequences. We want to get back to business as usual, right? That is a very dangerous approach to life and whichever. But again, it comes down to reassuming regular business operations and continuing to generate revenue is the important part. That's why our companies exist. It's just part of what our free market economy is and will always probably be that's there.
So it's the sense of urgency that you're saying is contributing to the willingness of companies to pay out higher ransoms. Okay, that makes sense.
Yeah. I mean, that's that was it. And so some of the smart early adopters of this, they found that these companies are going to pay out large settlements from that, or that they can pass that on to the insurance company, right? And say, okay, that's why we got insurance first, right? So your first adopters, well, they were the smartest out of the gate because they're like, hey, we are going to pass this risk. We're going to transfer this risk, right? But like I said, insurance companies are in the business to make money.
Right.
They will figure out a way to not have to pay some of that.
Yeah.
Right?
Well, in the case of the Colonial Pipeline, their cyber insurance did actually pay the ransom for them. Yeah. And there was some other hack that happened recently too, where the cyber insurance paid out the ransom.
Did the cyber insurance pay out the ransom? Colonial Pipeline sent the money directly.
No, it was I'm gonna look this up, but I'm about 90% certain.
That's why the CEO got chastised.
So I can't find it saying if the company paid it or if the insurance paid it.
Yeah, I think the company did because they did it was like a cryptocurrency transfer or so of those funds, and then those
I do remember
funds
it being crypto.
And those funds were re-seized by the U.S. government and given back.
Yeah, which that's a whole interesting thing because those crypto wallets are supposed to be like impenetrable and yeah. Though there is something here on the Googles that says ransomwares are paid out by insurance companies.
Yeah, they can be.
but it's there's a legal limit on how much and what they can pay out.
Yeah, they don't know. The company hasn't disclosed that the cyber insurance was what was paid out. But here it is. First, with the cyber policy in effect, the insurer would likely have stepped in at the onset of the time the company first discovered their system had been breached. So the cyber insurer is going to have somebody that's going to go in. They're going to have the forensic guy and everything else that's coming in to do that, right? And they'll pay for that because they don't want to necessarily pay for the fee. So they want to first probably see, hey, can we can we get
Yeah, they'll pay an incident
Yeah.
response guy to
yeah
get them
see-
out of paying the
see
bigger
if
one.
we can get this data back and stuff from there, right? But this would have been like the investigative fees, determine the cause, scope, and extent of the security breach, and identify affected parties, cost of legal fees, or other professional advice on responding to the security cost to notify. But yeah, it's not. I don't see where it says that it paid it.
I remember reading it like right after it happened. I might be thinking of something else, but
By and large, it's quite reasonable to assume that any amount of premium the company may have had to pay would not be near the $5 million ransom payment.
so they might have paid part of it, but not all of it.
Yeah.
Like reimbursed them or something.
I don't know if they'd do a reimbursement either on that. I mean, just because of the way the insurance is, it pays for fees, but it's it does not say that it's going to pay for the ransom, right? Yeah, it paid for expenses like your investigators and your people, your specialists and stuff too that came in. It paid for those types of things.
How can BlackRock help companies grasp and have a good foundation and understanding of the legal side of cyber?
So BlackRock, our experience is really in doing a lot of both the technical work as far as in cybersecurity and securing your organization with different tools, technologies, and capabilities. But really, where the rubber meets the road for BlackRock Engineering and Technology is in working with organizations in their compliance programs, understanding what are the different industry standards, state legislation standards and stuff that they have to meet, as well as federal and global standards for privacy and security. So we can work from both directions, right? One direction is this: we know how to keep a company compliant and in line with things like the provisions in a cybersecurity insurance policy, which saying that, hey, you need to maintain your hygiene and maintain your cybersecurity capabilities, risk management, and compliance practices in order to maintain this policy, right? We can help as far as instituting those and putting those in place. In addition to that, we also have an understanding how organizations can be approached both from consumers and others regarding their liability in both data breaches as well as in the controls that they should have had in place. So here's an example. We know from our experience that companies sometimes know about their security holes for 3 and 5 years, but never close them because they don't get the support from the executives in the organization to provide budget and resources in order to adequately address those areas, especially if they don't see a direct line to, hey, what's going to be the bottom line for this year, right? They still look at this as an expense rather than an enabler for their organization. Security is an enabler now for the organization to be successful. If you don't put these types of capabilities in place, if you don't follow a lot of the different frameworks and best practices that are in the industry at this point, the likelihood is that you are leaving yourself open to not achieving what we call due care and taking care of just the minimal cybersecurity requirements for your organization. So we know and have seen this for years that security in some cases have been the last thing to actually be applied in the organization or the last line item for the budget that's there. And with those holes, those are the things that get exploited. It's normally not some elaborate scheme or elaborate security breach that's happened. It's usually something very simple has happened, from a hole standpoint that either has exploited the fact that you're not monitoring employees and shutting down their accounts when they leave or are terminated, or even simple things like, hey, not putting things like end-to-end encryption and stuff within your organization so people can just sit there and literally see your credentials and stuff going across the wire within the org. right? So we can help as far as closing those gaps and closing those holes. We have both the approach as far as for the budgetary concerns that the board of an organization has, and being able to really bounce those against, look, here is the strategic position that you need as an organization to succeed. Here is the level of security that you need to have in order to do that on a regular basis. And here is how you burn down both risk and compliance, compliance impacts for the organization as you move through that. So that gives you a good picture of how you should move forward. So now you know what you need to do, why you need to do it, how you need to do it, and most of all, how to fix it should something go wrong or the circumstances change.
Makes sense.
So that's how BlackRock moves and works with our different organizations, supplying both that soft touch, compliance, and risk approach with really some exceptional technical talent to be able to help in implementing those things with your staff. All right, guys, that's all for this episode of The LoJo Show. Talked about some of today's cyber news and discussed the legal side of cyber. Let us know what you think of Season 2. You can leave a comment on our Facebook, Instagram, LinkedIn, Twitter, and YouTube pages. Or you can send us an email at officiallojoshow@gmail.com. We look forward to hearing from you. With that, we will say goodbye. Thanks for listening. Have a great week. Stay safe and stay secure.